Today, we are here to take a look at the Adelson case. There was a brief hearing yesterday. There is jury selection starting today. There is lots that we need to do. So that's what we are going to be doing today. Wendi Adelson's attorneys made a motion to quash a subpoena from the defense. Remember, quash means squash, get rid of. So the defense, Donna Adelson, Wendy's mom, through their attorneys, made a motion to subpoena Wendi into court to testify for the defense. Wendy's attorneys made a motion and said, so what we're not going to do is that. We would like the subpoena yeeted out the window. We're not going to comply. Remember, Wendi is also subpoenaed by the prosecution. But when Wendi is subpoenaed by the prosecution, the things that she testifies to in court can't be used against her in any subsequent prosecution if there is a subsequent prosecution of her. So there are protections when she is a state's witness. There are not protections if she is a defense witness, and they're going to get into that.
Yeah, so the issue as to immunity, we cannot confer immunity to her, Judge. We agree with that. We can't.
Right.
But there may be other issues where she could testify to something that she's not taking a chance, if you will, that she's going to say something that could be used against her in the future. There could be other matters that are raised in the trial that we simply want to get testimony from her as. She is the daughter of our client.
So
from the perspective of your client,
the relationship to your client's not what's relevant.
I certainly understand the argument you're making, Mr. Loro. You may argue.
Yes, Your Honor. This issue was addressed by Judge Wheeler in the second McBanawa trial. It was also decided upon by the first DCA in July 2025, when the DCA ruled that the procedure used by Judge Wheeler was entirely correct, and the subpoena in that case was quashed. It was the same issue that the defense raised, where they wanted to cross-examine my client pursuant to a defense subpoena, which conferred no immunity at all on Ms. Adelson. I indicated to the court then, as I will now, that Ms. Adelson will assert her Fifth Amendment rights with respect to any relevant question asked by the defense. So the only result of the defense procedure would be to have the client's daughter take the stand and invoke the Fifth Amendment in front of the jury. And that the court decided by Judge Wheeler that that would be inappropriate. And we would ask the court now to follow the same procedure as Judge Wheeler and follow the same procedure that was upheld by the first DCA just 1 month ago.
The defense cannot give the witness immunity as it relates to any matters in which she would testify under and could properly invoke the Fifth Amendment privilege. No witness can be called to the stand simply to invoke the Fifth Amendment, as there would be no basis for this witness to take the stand and give testimony on a relevant matter, and also could not affect her ability to also endanger her own Fifth Amendment right. I am going to grant the relief that is requested. If we need to revisit this issue for any purpose where the
He's quashing the subpoena. I'm going to grant the relief that's requested.
I'm going to read to you at this time a statement of the case that has been agreed upon by the parties. On July 18th, 2014, FSU College of Law professor Dan Markel was shot while seated in his car. This happened in the driveway of Markel's home on Trescott Drive in the Benton Hills neighborhood. The killers traveled to Tallahassee from Miami to commit the murder in a rented silver green color Prius. The defendant and alleged conspirator in this murder was the former mother-in-law of Dan Markel. She has entered a plea of not guilty. The statement of the case that I've just read to you is not evidence, and it's not to be considered by you as evidence or any proof of guilt. You must not be influenced by this statement. It is merely informing you of the accusation that has been made by the state against the defendant. I'm also going to read to you at this time the material part of the indictment that has been filed against the defendant. Once again, the indictment is not evidence, and it's not to be considered as evidence or any proof of guilt. You must not be influenced by the fact that an indictment has been filed in this case. It is merely a formal method by which the state makes an accusation against the defendant. It is alleged in count 1 that on or about July 18, 2014, Donna S. Adelson in the county, Leon, and state of Florida did unlawfully kill a human being, Daniel Markel, by shooting with a firearm, and the killing was perpetrated from or with a premeditated design or intent to effect the death of Daniel Markel, contrary to the Florida statutes. Count 2. Beginning in 2013 and until October 1st of 2016, Donna S. Adelson in the county of Leon and state of Florida did agree, conspire, combine, or confederate with Charles Adelson and or Catherine McBanawan and or other persons to commit first-degree murder, contrary to the Florida statutes. Count 3. It is alleged that beginning in 2013 and until October 1st of 2016, Donna S. Adelson in the county of Leon and state of Florida did solicit another to commit first-degree murder, and in the course of such solicitation, commanded, encouraged, hired, or requested the person, Charles Adelson and or Catherine McBanawan, and or other persons to engage in specific conduct which would constitute first-degree murder, which resulted in the death of Daniel Markel, contrary to the Florida statutes.
3 weeks. Opening statements as soon as Friday, but they could be sooner if the jury gets picked sooner. If there's a jury sooner, I'm going to let you know in the Lawnerd app. So we are getting ready for the trial of Donna Adelson, which could start as early as Friday this week or earlier, or Monday, August 25th, 2025, on those 3 charges: murder, conspiracy to commit murder, and solicitation of murder. They are in the process of picking the jury. It actually started. They are in the middle of jury selection. And yesterday, August 18th, the court ruled that the defense cannot subpoena Wendi Adelson, cannot have her testify, that she will be testifying for the prosecution under their subpoena, which grants her derivative and use immunity for the things that she testifies about in court. The defense can cross-examine her in the bounds of that direct examination, but they cannot call her separately to testify. Interesting to me is that the defense said, well, this is a different situation than prior trials because Donna Adelson is Wendi's mother, and there are different things she wants to ask. There is more that she knows. We've also heard the defense say clearly that Donna Adelson is going to testify. That will be once we get into the defense case in chief. I suspect we won't see Charlie Adelson, but who knows? The court gave the jurors the expectation, the charges, a brief overview of the case, and then told them a little bit about what the individual voir dire process will be. The individual voir dire process is going to be jurors one by one. Why? Because what you don't want, and this is me just making something up, for example, but you don't want a juror to sit there and be like, yes, I have listened to podcast, news, newspaper, YouTube, nightly news about this case. And yes, I have formed opinions about Donna Adelson. And I also have opinions about Wendi, Your Honor. Let me tell you what. And then that individual just in front of the entire courtroom and everybody is like, I think she's guilty. I think that one's guilty. I'm glad these were charged. I know that Charlie's in prison. What else do you want to know? Because then the rest of the jurors sitting in the courtroom are like, ooh, tea. But it's information that they may not learn throughout the course of this trial. So you do it one by one so that the jurors can tell the court honestly what they know about the case without everyone else hearing it, because once the shit's out of the horse, there's nothing you can do. So that's why they're doing individual voir dire, especially in a high profile case, because some people are going to know about this case and you don't want the other jurors that don't know, because now they know. They try to prevent it from infecting the rest of the jury pool with information that they don't otherwise have, because they are looking for jurors who don't know much about this case, or like, oh, I think I might have heard that when it happened, but I haven't really followed it. Wasn't that in 2014? I don't know. A lot of shit's happened between 2014 and 2025. Those are the type of jurors that they're looking for, because it's not that you can't know about the case. It's that you can't have formed an opinion about the case. So if you heard a thing then you heard a thing. So Law Nerds, we are back in trial. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.